the word of prayer. Then we are going to proceed from there. So let's pray. Our Father, what in heaven, Lord, we thank you so much for today. We thank you so much for bringing us here. We thank you so much for this meeting. We thank you so much, Lord, for this session. Lord, as we share today, as we learn today, as this class tries to answer the questions that we have scheduled for today, King Jesus, may you guide them, may you help them, Lord. Through this session, may we learn 2 or 3 things. May we get better and better, King Jesus. May you lead us and guide us. May you take over this session. And it is in your mighty name that we pray and believe. Amen. Okay, all right. I see we even have 61 people. So, yes?
No, I was just saying amen.
All right. So, John, welcome to the session again. Now, John tells me that your orals are starting soon. You guys already have dates. You know when you're going to begin your orals. I think that is really nice. That is really nice. For those who are in the first week, I want to wish you all the best. As usual, just keep pushing, just keep going. This is possible. No anxiety whatsoever. I know sometimes you might have a few anxieties, but it's going to be all right. So I'm going to welcome our moderator today, and that's going to be Hesbon. So Hesbon will be moderating this session today. Please, let's ensure that we give him ample time. Let's ensure that we give him an easy time, and let's ensure that we cooperate. So Hesbon, you can take it away.
Hello guys, thank you so much, Daniel, for the introductory remarks and for leading us in that session of prayer. So now, guys, we've been officially invited to the session. This is our 10th session. The 6th session. So welcome to our 6th session, and it's a culture that we've been doing. So I think we understand how we go about it. It is usually a success when we volunteer. Yes.
It's our 10th session. Just at the link, it's showing 6, but it's our 10th section. Yeah, it's our 10th session.
Great. Wow, these are milestones we've really met. Anyway, it's our 10th session. Welcome all, and I think it's a culture which we've really taken our time to build. We're just subsuming in it. So we are doing the same style, and it's been a success because of how we've been volunteering to do. And seeing like your orals are around, I really expect that we volunteer, and if you will be many in number, we can actually have few times for each so that we give many people a chance. But again, we can always learn from each other's volunteering. Today, I'll really request people, especially who never volunteered, to maybe have a chance. Anyway, before we begin, allow me first to recognize the moderator, the panelists who are present. I know we have, I think I'll call him a guest because he's never been this. He's our senior. So I'll first request that you allow me to introduce Patrick Lavins. I don't know if he's on call. Patrick, are you on call? Right, I'll check with him. But he's meant to join us. Okay, as we wait for Patrick, maybe just allow me to recognize other panelists. I think Oduor is one of them. Oduor, now you can come in the style of a panelist. Hello, how are you?
I'm good, sir. How are you?
Well, thank you. Now, I think I've seen Makwe Angelo Hamduni. Kanso, how are you?
I'm doing great, sir. How are you?
Very well. Do you have any other panelists? Do you have any other panelists? Okay, I think some of them will join us as we start. Now, usually before we begin, we usually have that session where we can have, maybe in the course of your reading over the week, we've come across an issue that you may want maybe to hear pronouncement from us. So if you have an issue where you're still having, and maybe you like trying to find a reconciliation of the thought, you're not able, or maybe a thing an issue you want a clarification on, we invite at this time. So I'll throw it to the floor for any issue. Just raise your hand, I'll pick you. Do you have any person with any issue, any question? I can see we are 87. I know there could be an issue, one or two, maybe before we begin.
Hi, Hesbon.
Hi, how are you?
I'm good. My hand is up.
Oh, sorry.
Yeah, no problem. I'm seeking a clarification in simple terms of consolidation and tacking of charges in the simplest words possible. Thank you.
Okay. I think it's Alice asking. So Alice is asking the difference between consolidation and tacking of charges. So let me, as you request, let me just be brief, but I'll want to serve the purpose, whether brief or wordy. Anyway, I hope to be tough as you request. So the difference between consolidation and tacking is first has to begin with different types of charges. So we understand that there are various types of charges where we have the charge can be the first charge, the second charge, subsequent charge, so that you have, for example, you as Alice, then I as Hesbon, then you have bank equity and bank cooperative. So let me just be practical. So Alice, you have a parcel of land whose value is 50 million. So you approach Equity Bank and request that a loan of 20 million be advanced to you. So in return or in security, you deposit your title. So that is a loan of 20 million, and that will now become your first charge. But then you realize that you still need more money. So what you do is that you again advance, you have an advance loan over the same title, so that maybe let's say you get another 20 million, so that you have 40 million of the same title in the same bank. Now, the first 20, let me use 20 and 10 for the second so that we get the difference. So for the first 20 million, it will be called a first charge. Then the second one, it will be called a second charge or a further charge. Further charge actually. So in other case, there could be an issue where, for example, the first example is you're taking loan in one bank. I said Equity. Now, in a different scenario, you have a title that is worth 50 million. So what you do is you approach Equity and you take a loan of 20 million. Then you also have an account with Cooperative. So you approach Cooperative and take a loan of 10 million. So now what happens? You understand that you have in these two banks, you have like two charges. So let us start with the first scenario. In Bank A, which is Equity, you advanced a loan of 20 million. You also advanced a loan of 10 million. So that 20 million is the first charge, then 10 million is the second charge. So to get now the difference between consolidation and tacking, that is where these are the scenarios that will bring the differences. So in preparing a charge instrument, you usually have a clause on consolidation, a clause on tacking, so that you reserve the right to tack and you reserve the right to consolidate. No, the consolidation may not really happen. You may not be able to reserve consolidation, but tacking usually is reserved. So at what point do you tack? So tacking refers to the right of the chargee to discharge discharge their charge. I don't know which word I can use. Let me just use the example I used. So let's say, for example, you have the Equity. So Equity Bank gave you a loan of 20 million, then further gave you a loan of 10 million. So in total, Equity has you owe Equity 30 million. So consolidation will come in the sense that, for example, if you default in payment, or for example, you want to discharge your property and you say, I first want to discharge 20 million. Equity Bank will tell you that you cannot really discharge this property because we have consolidated your two charges, so that the 20 million charge and the 10 million charge have been put together. So you understand now consolidation refers to the charge you took in the same bank, first charge and the second charge being put together by the chargee, so that you cannot discharge either of them. You have to discharge both of them a go. Like that happens, for example, if you use different titles. You're using, let's say, for example, land in Kitui, another land in Machakos. So then you say you want to discharge land in Machakos. And unless we have consolidated these two charges of yours. So you'll have to discharge both of them at a go. So that is called consolidation. So consolidation happens in the same financier, for example, the same chargee. When you come to tacking is where now we have two different banks or two different chargee, where, for example, you have cooperative and you have equity. So if equity is the first bank to give you a charge, they will have a clause to say, we reserve a tacking right, so that in the first instance, they give you 50, then you go to cooperative, cooperative gives you 20. Then you come back to equity after you take another 20 million from cooperative and you take extra 10 million, so that you have 60 million from equity and 20 million from cooperative bank. Now, in the case of now default, remember equity in giving you the 50 million said that you will reserve the right to tack, so that the 50 million is tacked with the 10 million, so that they have they have priority over cooperative in discharging their 20 million. I know it's getting complicated, but I hope so you'll be able to follow. So tacking happens. There are two chargee. There are two banks, for example. The first bank gives you the charge. Then you go to another bank, they give you a charge. Then you come back to the second, to the first bank, they give you a second charge. So that to the first bank you have two charges, to the second bank you have one charge. So what happens is the first bank reserves a right to tack, so that the first charge and the second charge is tacked. Like you cannot discharge, like they become like one. I don't know. Maybe I'll request somebody with few words to explain the two, but that is what tacking and consolidation really mean. Yeah. Maybe Angelo or Oduor can come to shed light on.
Okay. Esbon, can you hear me? Hello? Can I be heard?
Yes, Angelo. Yes, please proceed.
Yes, yes. It is just simple. You see, tacking is just all about priority. Okay? You see, Bank A lends you some facility over your property. Then you go again to Bank B, you borrowed some amount. Then again, you went back to Bank A to take another facility. So, of course, Bank A has priority with regards to the facility that you first took. But on the second one, it doesn't have priority over Bank B. So what it will require, therefore, is to tack that second charge that you took, or the facility that you took, that is with the exception, with the consent of Bank B. Okay, so tacking is all about the priority. Okay, whereas when you talk about consolidation, is that if you have charged, let's say, two properties, and now they have matured, you cannot redeem one property. The bank can say no. You have to redeem both properties. Okay, so the bank will not allow you to maybe redeem one property that you have defaulted in. It will only say no. I have to consolidate all the facilities that I have advanced to you over all these two properties. So that is consolidation. So you will not, the bank will not give you a leeway to say, let me just redeem one property and I will do this one later. No, it will have to consolidate. So that is it in few words. I don't know, the conveyancer is Daniel. I don't know if I have attempted well.
Well, thank you so much, Angelo. Yeah, I think from Angelo's explanation and from my wordy explanation, you get that this thing comes with priorities. Like tacking is where you're prioritizing to redeem your loan you advance to someone. and it's because you reserved that right in the first instrument you drafted. Then consolidation is where you're just denying a person from like discharging or discharging one property, so that if they had actually secured a loan using two property, you tell them that you can only discharge all property at once. You can't discharge one of them. So where you bring the two charges together, that is consolidation by same bank. Let me use bank by same charge. But where now there are two banks, one bank reserving the right to redeem, then that is where we bring the aspect of tacking. I don't know if that will be clear, Alice.
Yes, that is clear. I was a little bit confused because we had a different explanation on the same. And the lecturer was of the opinion that consolidation happens where we have two different charges, and tacking happens where we have one chargee, and then now the charger is the one who's building up on their credits. So I was a little bit confused because section 83(1) provides differently. So I just needed that clarification. Thank you.
Okay, thank you. Can we start, or we have someone else with a burning issue? We can maybe have it at the end so that we begin. Do you have any other panelist who's joined us today, other than Angelo and Odua and myself? I don't know if Lavins has joined us.
Husband, I see Lavins is in.
All right. So allow me to introduce. So Lavins is actually our senior. They used to do this sometimes back, I think in 2020 or 2020. And so they are pioneer organizers of this event, this session. So today he really requested to join us, and it's a privilege to have him today. So allow me to give him a chance to just introduce himself. Then you will interact with him as the session proceeds.
Thank you, Husband. Can you hear me?
Loud and clear.
Boy, fantastic. Well, greetings, ladies and gentlemen. My name is Patrick Lavin, so you could call me PLO. Well, I'm an advocate of the High Court of Kenya, and I'm delighted to be here. As Husband had adequately put it, we were the COVID class. We call it the COVID class of 2020. And the first class we took through such tutelage was the class of 2021, 2022. So we had such a setting. I mean, every Saturday at this particular hour of the day, and it feels nostalgic to come back, but this time with a different lot. And I don't know if I've interacted with a few of you, perhaps when we were at the Kenya School of Law, and just the other day, I think this week and a week ago. So I have so much to pour, so that at the end of the day, you all feel a little bit, calm, because I understand you'll be doing your orals on 24th of this month. So it's a good place to be. I mean, the anxiety. I mean, that's what makes KSL worth this particular journey. So I would be looking forward to perhaps I don't know how much I will contribute today or in the subsequent classes, but I hope to at least leave a long-lasting impact, just as we did with the more than 1,600 students in the 2021-2022 class. And I'm glad majority of them right now are advocates, and I hope you also got to join them soon enough on this other side of the profession. So the bar is beautiful on this other side. So I'm looking forward to perhaps got to contribute however modicum it could be, but at the end of the day, it's the impact and how much you got to decipher, how much you got to pick from such settings. I mean, this is just an add-on or an icing on the cake which you have been baking all this while. So it's just an additive that perhaps, is always added on food as preservatives to prevent them from decaying or going bad. So such sessions are welcome, and I thank Esbon now that you guys have contributed and have picked up where we last left. So our hope and our prayer and our solemn supplication was that this could be something generational, something sustainable. So even you, when you are admitted as advocates, you could take another class through such sessions. So I'll be listening in, and when Husband, you would want me to contribute on one or two things, perhaps on oral preparation, the board exam, which I understand will be done in November, because CASAL is trying to revert to its old calendar. So I think with that, Husband, back to you in studio. Thank you.
Thank you so much, Lavin. I don't want to, the greatness of your words can never be overstated. So I think we will begin the session. So first of all, of course, the first panelist shall be Angelo and myself. Then the second session shall be communicated to you, Lavin, I think, and the doer, because we are 4. So do you have any volunteer? Somebody to go first? Somebody who want to get the first blessing? Oh, I can see Lual John. Lual John raised the hand. So I think we can begin with John. Angelo, I request that you start.
Okay, thank you, Esbon. My questions will be brief, John. John, how are you?
How are you, Mr. Market?
Okay, I'm fine, thank you. I'm going to ask you a few questions. John, can you please introduce yourself? Assume that your oral session is in the morning.
Okay, thank you. My name is, good morning, panel. My name is John Rongwal, a member of Class B, Term 9. And my registration number is 2023-1614. And I'm ready to proceed. Thank you.
Okay, thank you, John. John, please, in under 1 minute or so, please differentiate the following for me. A verifying affidavit, a replying affidavit, and a supporting affidavit.
Okay, thank you. Verifying affidavit, this is an affidavit which shows or to give or to show that the motion or the support that the place has is using as an evidence for that matter. But according to the affidavit, these are the these are the these are the these are the evidence that are used to support the motion. And which other affidavit verifying affidavit, supporting affidavit, and which other one? Hello?
John, proceed.
Your background is very noisy, so noisy. So I forget the third affidavit. I got only 2 supporting and supporting affidavit and verifying affidavit. Which other one?
The other one was replying affidavit.
Oh, okay, thank you. Replying affidavit, this whereby you this is an affidavit which is used to make a response of the matter raised by the other party. Thank you.
Okay, so John, what is the rule in the Takwan's case?
The role of
The rule. What is the Takwan's rule?
Takwan's rules.
Yes.
No, in that case, I'm not conversant with that case.
Okay. Please, John, state for me any 3 remedies in contract.
Okay, thank you. We have we have profession in contracts whereby in a contract when a party fail to perform its obligation in the contract, especially the party fail to complete its duties in that contract, then the vendor will forfeit that deposit amount, like that 10% will not be refunded if the fall come from that side of the purchaser and then
Garang, I'm asking,
yes.
generally in contract law, in case if there is a breach of contract, please state for me what are the remedies.
Okay.
Generally.
Okay. The remedies we have resins whereby the contract will be cancelled, and we have the this one. We have specific performance, and and we have we have this we have monetary compensation.
Okay, thank you. Esbon, you can take over.
Well, thank you so much, Bwana Angelo. Now, John.
Yes.
Good. I'm going to ask you a few questions. And the first one is, what is your understanding of, and what's the difference between default judgment and summary judgment? Just briefly about them.
Okay, thank you. Default judgment is whereby a party failed to come to the court if that party has been served with the motion has been served, the notice has been given to that party to appear in the court, especially when that is a respondent or the yes, if it is the respondent and not the plaintiff. So then the judgment will be made against that against the respondent. So, but summary judgment happens whereby both parties appear, but they all present their cases, and yes, they all present their cases, and then
okay, thank you.
There is a term that I want to use, but it just escapes.
Okay. Now, quickly, what are these 4 things that must be present for you to request for a summary judgment? The 4 things that must be present for you to request for the summary judgment, or any that you can remember.
Okay, for one to request a summary judgment, there should be a prima facie case, and there should be there should be there should be a referable damages that should not be compensated, and maybe the site of a defendant act in a manner that affected your right has been violated in simple terms. So that's what I can't remember.
Okay, thank you. The second question to you is, you understand what titles to land mean?
Yes.
Okay. Would you maybe give me some ways of acquiring titles to land, and if you know any legal provision that provides for the same, a legal basis for the same?
Okay, thank you. For one to acquire the land, you acquire the land through the first things should be you should enter into the contracts, and then you follow the rules of contracts or the laws which are applicable to the contracts by doing the due diligence, whereby you do the searches and free contracts, and then you make a requisitions and the completion of the contracts, so that you have a clean title of the land.
Okay, very well. So the last question to you, John, is you understand that advocates can actually get into different types of agreement, right?
Yes.
Okay. So I'm now particular about these types of agreements that advocates should not get involved in. What are they, if you know any?
Okay, thank you. Advocates are in Advocate Act section 30. It is 33, I think, but let me not be quoted, because maybe I've misquoted the section. So advocates are not allowed to make a contract with their clients, and the first thing is that they are not allowed to make a contract like to promise the client, or to promise the client that whenever the outcome of the case, you will add this amount of the money, or the client will promise the advocate to 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 to, to reward him based on the outcome of the case. And also, they are not allowed to have a portion of the disputed property of the client, and also they are not allowed to give the to make no, they are not also allowed to commingle the asset of the or the properties of the clients. Thank you.
Oh, thank you so much, John. I think that has been all for us. So I'll allow Angelo to give some brief feedback about it.
Okay.
Thank you, Esbon. I believe my questions were straightforward, so I'll go to it. I believe my first question was about verifying affidavit, replying affidavit, and supporting affidavit. So, John, verifying affidavit is one of those documents that you file together with your claim, okay? And the purpose, that particular document, which is the verifying affidavit, is that it states, the verifying affidavit states that the averments made are true. So whatever that you have stated in your claim, so you have now to support it. Let me not use the word support it, but you have to state that whatever that has been stated in that particular claim is really true and it is the correct position. That you have indeed read that particular claim, okay, and that whatever that have been said in that particular claim is true. All right. In some instances, for example, a divorce petition, it is also supported by a verifying affidavit. Replying affidavit, on the other hand, are filed in response to the facts raised in the supporting affidavit. You file it together with a notice of motion. Sorry, all right. Supporting affidavit, you file it together with a notice of motion. But replying affidavit is used to respond to an application. If you look at your order 51, there are three ways of responding to an application, one being the replying affidavit, the grounds of opposition, and the notice of preliminary objection, okay? So this one, therefore, is used to respond to an application, and more specifically, you use to respond to, let's say, whatever that has been stated in the supporting affidavit, okay? Then the rule in the Taquan's case, that is the Royal British Bank, I believe Daniel have asked this question severally. So this rule states that people transacting with a company believe that internal matters are handled properly and cannot inquire as to how the property is run. The Royal British Bank case, it is called the indoor management rule. So the people who are outside cannot know the internal affairs of any company or how the company is run inside there internally. Okay, so it is called the indoor management rule. Okay, I believe my other question was the remedies that is in contract generally. You tried that one, though you have damages, specific performance, rescission, repudiation. Okay, so those are some of the remedies that you have in contract. So I believe that was all on my part. So you tried well. I also encourage you to go and read and to be precise in your answers and try to get to read. That is what I'm saying, so that you can give precise and concise answers. So that is it on my end. Esbon, take it away.
Thank you so much, Angelo. Now, John, I believe you're still on call so that you're giving feedback. You're listening to the feedback.
Yes, I'm listening.
Thank you. So I asked you about some 4 questions. I'll go randomly. So the first, one of the question I asked you was whether you understand the title to. Yes, sorry. The question was ways of acquiring titles to land. And on this one, I'll invite you to go read Section 7 of the Land Act. It will give you different ways you can acquire the title. And for example, one of the ways that if you have a private lease that goes for a period of 21 years, that is like a long-term lease, you will get a title. For example, transmission. So different ways of acquiring title are actually provided for under Section 7 of the Land Act. So kindly just go refer. Then another question I asked you was different types of agreements that advocates are not allowed to get involved in. I think you got the first one, but you didn't mention it. You explained what it is. The one where you said that you're not supposed to get into an agreement where you agree with a client on the amount to pay if you win or lose a case. That is what we call the contingency sort of agreement. So you're not supposed to undertake such kinds of agreement. You're not supposed to get into agreements that you cannot be held liable for negligence. You're not also supposed to get involved in agreements where you are undercutting. So to get no further, you can go refer to Section 46 of the Advocates Act. You did mention, but you mentioned Section 33, and you see now the challenge is, much as the first answer was right, you had given me a wrong provision, and that is actually to your prejudice. So be careful with mentioning the provisions of sections of law. Then the last question from my end was to differentiate between summary judgment and default judgment. I think you did try, but you need to mention clearly that you have failed to enter appearance. You have failed to enter appearance. So that is, for example, the defendant has failed to enter appearance. So in that case, the plaintiff will go request for a default judgment. And I can also tell you to go read about default judgment, both by the government and by an individual, because you meet people like Mongare will ask you the difference between the two, so that do you request in individual, so you apply in individual. You need to know the procedure for both. But the different in default judgment, it is you have failed to enter appearance despite the service issued upon you. Then on the other side, summary judgment, it's where now the ground I told you about comes. There are usually four. The first one is the suit was started by way of a recognized plaint. By way of a recognized plaint. Number two is that the amount that is being sought or requested is actually a liquidated claim, so that you know exactly amount that you are claiming from this person. Number three is that the person has entered appearance but has not filed a defense, or the person has filed a defense but the defense is not surmountable. Insurmountable defense. The defense does not really like warrant to be a defense. So in that case, you apply for you request for a summary judgment. So those are the four, we call them the four corners of summary judgment. So those are some of the questions we asked you. I don't know if you have any question for us.
There's no question. Thank you.
Okay, thank you so much, Garang. Well, we wish you all the best.
Can you kindly repeat the four corners of summary judgment, please?
Okay, so the four corners of summary judgment is: one, the suit was commenced by way of a recognized plaint. The suit was commenced by way of a recognized plaint. Number two is that the claim is a liquidated claim. You know that you want 50,000, or you want amount that is 50,000 plus 20,000. So it is just arithmetics that the court will allow. It's a liquidated claim. So recognized plaint, liquidated claim. Then the third one is a person has entered appearance. That is very important. And the other one, they have not entered appearance, but on this one, has entered appearance but has failed to file a defense. Entered appearance that has not filed a defense. And the last one is a person has filed a defense, but the defense is not surmountable. Defense is insurmountable. It does not really disclose defense that you will deem a defense, the substance of a defense. So in that case, you know, like this one will fail ab initio. You proceed to apply for the summary judgment. That will be it. So thank you so much. I hope so it's clear, Mohammed.
Oh, yes, thank you.
Okay, thank you. So that was the first session. We will have the second take, and we request then, I can see Mutunga Nicole has raised her hand. So Mutunga, you will be the second person. Daniel, are you on call?
Maybe can we ask a question just on the same issue of surmountable evidence, surmountable claim, surmountable defense?
Okay, please proceed.
Yeah, just a quick one. There is a bit of a thin line on the use of the word surmountable, and I captured that the person has filed a defense which is surmountable. But you said that the defense must be insurmountable. And my understanding of surmountability is something that can be overcomeable, you know. So I was thinking if the defense is weak, then it is surmountable. And if the defense is strong,
Right.
then it's insurmountable. Maybe from what angle are we using the word surmountable? Thank you.
You are very right. It's actually surmountable. That the defense is very weak on the face of it. So that is why, like, as a plaintiff, you see, for example, you understand there is a different ways of replying to pleading. So where a person has just traversed, where a person has traversed and you feel like it's a very weak defense, that is when you proceed with summary judgment. So that is why we say has filed a defense, but the defense is very weak. In another term, it is like surmountable. So that is why. That is it. So thank you for that clarification. You're right. Okay, Nicole was ready to proceed. I was asking out. Oduor, you on call?
Yeah, I'm present.
Okay. Please take the mantle. I think you will do it with Patrick, so you can guide through.
All right. Thank you. Nicole, how are you?
Good evening. I'm fine.
Okay. Is it your first time or this is your second time?
Second time.
Okay. That's fine. Kindly just introduce yourself.
Name. Good evening. My name. Okay, I think there's a bit of feedback on your side. But good evening. My name is Nicole Mutunga. My admission number is 2023-1601. I am a member of Class C. I'm currently doing the Advocates Training Program.
All right, that's fine. So I'm just gonna ask you a few questions. Can you still hear the feedback?
No.
All right.
Actually, slightly, but it's okay.
Okay. Nicole, what's the difference between tacking and consolidation in conveyancing?
Okay, so tacking and consolidation of charges. So for consolidation of charges is where a lender refuses to let a borrower who has secured their loan with multiple properties to redeem one of them. So it basically deals with that. While tacking is something that has to be expressly reserved within the charge agreement, where it allows tacking. Wait, tacking allows for okay. Can I just read further on it? Because I know tacking deals with the priority of charges, where there are multiple chargees.
So priority in what sense? Or you wanna read on it?
Yes,
Okay.
I would prefer to read further in order to properly answer that question.
All right. So my next question. What's your opinion on the use of ChatGPT by lawyers to draft pleadings? What's your opinion on the use of ChatGPT by lawyers to draft pleadings?
My opinion is that it raises several ethical issues in terms of ensuring the quality of the work is that is demanded within the profession. There have been very many instances where ChatGPT has been used to sort of write various documents, and it relies on fraudulent sources and perhaps cites cases that aren't in existence. And there was an instance a few weeks ago in the US where an attorney was accused of using ChatGPT to write their pleadings, and it sort of came about because when the pleadings were brought before the court tried to traverse the cases that were cited and found out that they were not in existence.
So basically, you're saying that it's unethical to use ChatGPT to draft pleadings.
Yes, it takes away from sort of the trust that is placed by a client to an advocate by sort of forcing by putting it in the hands of a program that hasn't been licensed or trained to sort of work within the legal realm. So I think it also violates the rights under the consumer protection laws.
In what sense?
So within the Constitution, I think it's under Article 36 of the Constitution that deals with consumer protection rights. And I think it's one of the rights under consumer protection is to have rights, it's goods or services of an adequate quality. So it is in violation of their rights when they're provided with substandard services.
Okay, that's interesting. I thought ChatGPT can give you the best. Anyway, my follow-up question: do you think our legal framework requires new laws to regulate AI, especially when it comes to the practice of law, or do you think that our legal framework is enough to deal with this particular issue?
So my opinion on that is I think it is insufficient for our legal framework doesn't contain sufficient provisions in terms of regulation of AI because it's a largely unregulated space. However, there must be caution exercised because at the rate in which AI is developing right now, with ChatGPT being the best example, and also programs like DALL-E being rolled out, it would be very difficult to regulate AI comprehensively because it's hard to foresee the sort of changes that may happen within the field. But I do know that there's a very careful line to be walked in terms of regulation of AI, as you want to regulate AI to sort of limit its more harmful effects, but you don't want to stifle any development or growth within the sector.
All right. My next question is on this. Now, a client has come to your chambers and they have a property in Nairobi. Now, they believe, or rather they are told, that their property has been gazetted for conversion. They believe that their property has been gazetted for conversion. Now, they have also heard about this platform called the Ardhi platform. They'd like to sell their property to person X. What is the procedure?
So if the property is being converted, it would be converted from probably a freehold interest towards a leasehold interest. And the main difference between the two is in terms of the duration of both interests. So in terms of the process for both, there would have to be a due diligence stage where you do an investigation into the property and on the title. So you would have to do a historical search, an official search, and a personal search, as well as conducting due diligence such as visiting the site property to sort of try and discover any patent defects that might be examinable on the face of the property. Then you can move towards the pre-contract stage where parties sort of receive a letter of offer in terms of the property and can negotiate the terms of the property. Then they will enter into a sale agreement, and a sale agreement will essentially contain a description of the property and any other clauses that are necessary, such as description of the parties, the interest that is going to be transferred, and such. Then lastly, there would have to be the transfer of the property, and this is also the stage at which stamp duty is paid. And since the property is within Nairobi, stamp duty shall be payable at a rate of 4%.
All right, that was my last question. Patrick, if you're available.
I'm here, thanks. So are we proceeding with the same person?
Yep.
Thank you. Hi, Nicole. Can you hear me?
Yes, I can.
How are you?
I'm fine, thank you.
Are you nervous?
Slightly, but not too bad.
All right, let's now get into the deepest of waters. So Order 51, Rule 13, the CPR provides that a court may at any stage of the proceedings order to be struck out or amended any pleadings in an action for anything in any pleading on a number of grounds. So just give me 3 grounds under which a court may strike out pleadings.
So 3 grounds on which a court may strike out pleadings is where it is an abuse of the court process, where the pleadings are vexatious, embarrassing, in terms of the litigants. So the point of them is to embarrass, frustrate, or vexate the parties, one of the parties to the pleadings, and then where there are no reasonable grounds, where there's no reasonable claim under the suit. So this was laid out in the case of DT Dobie versus Mushina, and I think it's also laid out within Order 2, Rule 15 of the CPR.
My next question, what are the 3 circumstances under which a court may make an order in a grant of letters of administration with will annexed? Just give me 3. I know there are quite a number, but I just need 3.
The 3 scenarios is perhaps where the...
Perhaps, or you know. Which one is it?
I'm not very familiar with the area, so I'm just...
So do we pass it?
Yes, we can pass that question.
Thank you, because we are trying to save on time, not just ours, but yours as well. So my next question is, what's the difference between a judgment and a ruling?
The difference between a judgment and a ruling is, the main difference is the stage at which they are made at. So a ruling is made in terms of during the course of the litigation, while a judgment is the final pronouncement of the court that is binding upon the parties.
So what do you extract from a ruling that you can't extract from a judgment? And the inverse is equally true. What can you extract from a judgment that which you can't extract from a ruling? So, and I think that's one of the distinguishing factors you didn't mention. So I just need that clarity.
So you can extract a decree from the judgment, and you can extract orders from a ruling.
My next question, can you assume the other day Justice, the Lady Justice of the High Court, Honorable Mugure Thande, extended conservatory orders against the Finance Act 2023, which has not been operational. So the respondents, advocates, raised a question or an application for stay of proceedings of that particular ruling that was made. But she declined to grant those particular orders and suspend the orders she had prior given. So what are the 2 types of recourse that the respondents advocates could invoke to ensure that they do perhaps seek redress out of, I don't know, could be the same court, could be higher court? You tell me, what are those 2 redresses here?
So the 2 redresses would be, the first one is review, and that is where the decision is reviewed by the same court and the same judge. And then the second one is appeal, where it goes to the next level. So the next level would be the Court of Appeal, and the case would be redetermined afresh, involving both the questions of fact and the questions of law at that stage.
Okay, thank you. So you've mentioned the review. Assume now the respondents advocates have chosen to go for review. Do they still have an option to appeal if the review fails?
Yes, they do still have an option to appeal.
Are you sure?
Yes.
All right, thanks. Just hold it there. So given that they have an option to appeal, but while I'm still hell-bent on the review, so if the review again fails, can you review a review?
No, you cannot review a review.
All right, thanks. That's it. My last question is, you've had so many people, I mean, perhaps these are people you may know, and even in the legal spheres, they keep on saying, okay, fine, I have been enjoined in a suit as a, interested party or God knows what. So what's the difference? Or do you think that's the right term to use, enjoined?
No, the right term to use is joinder of parties, and joined actually is where one of the parties is severed from the suit or
So
excluded
what's
from the suit.
so what's the difference between being joined and being enjoined? So that you at least set the record straight for those who are listening, that you may not use a given term in substitute of the other.
So a joinder of parties is where perhaps there are two litigants in a suit. However, there's a third person or a third company that should be joined to the suit, and without which the matter should not proceed without them being joined. And enjoinder is where a party is removed from the list of litigants to a matter. So perhaps there were 3 respondents. However, one person was wrongly joined. They should file for an enjoinder to sort of have themselves removed from the matter before the court.
Are you sure?
Yes.
Well, thanks. Well, I'm done, Hezbon. So I think I'll just give a feedback after the first panel did. Thank you.
Okay, thank you so much. I think Daniel will start with a feedback, and then you can take over.
All right, Nicole, you can hear me, yeah?
Yes.
All right, so I respect your opinion on ChatGPT and whether advocates should use it to draft pleading. It was an open question, and I think whatever answer you gave makes sense in my opinion. Now, I also asked you about AI, and I asked you whether our laws are sufficient to regulate it. And you had your opinion, which I also respect. And what I like most is how you went forward and talked about regulation and growth. I mean, that's a debate that will exist probably forever. And just the fact that you say that we need to balance it, because again, if we have too much regulation, then we are going to stifle our growth, and that's going to be a problem. So while the whole world is changing, we are going to remain at the same state we are for a very long time just because we're scared. So I like the fact that you went past just giving me the answer, but also talking about that particular balance. Now, I have an issue with your answer on TACAIN. Now, consolidation was proper. TACAIN, you have an idea about it. It's on priority as stated by yourself correctly, but you aren't able to explain the answer. Now, the reason why I asked this question is because just when we started this session, I think there's Alice. Alice asked the difference between these two. And I don't know if you are present or not, but I was just asking to know whether you're paying attention during that particular time. Now, as stated by yourself correctly, consolidation is where we have 2 properties. We have one chargee. Now you've charged one property X to me for 10 million, property Y to me for 6 million. Now you want to pay the one for 6 million and probably use it for something else. Then I tell you that what, you have to probably pay the 10 million too for me to release the 6 million. So you have to actually, I'm consolidating the 2 charges. You have to pay them together, or you have to pay one for me to release the other. Now, we also talked about TACAIN in the first minutes of our session. Now, in TACAIN, we say that we have 2 charges, we have 1 chargeor. So probably your property is worth 100 million. It's charged to DTB, for example, for 50 million. You've charged it to equity for 10 million. Then you've charged it again to DTB for another, let's say, 30 million. So there's 10 million because of valuation and everything. So DTB has a first charge, then we have equity with another charge, then we have DTB again with another charge. Now, DTB would decide and tell you that, they have priority when it comes to payment. Since it's one property, when you are paying DTB for the first charge, you also have to pay for the second charge before you go ahead and pay equity for the second charge that they registered. I know I'm using second charge and third charge in that order, hoping that you know the difference where we have 2 charges and we have the same property. Probably the names would be different and not as I've stated them. Now, we've also talked about conversion. Now, I think I've had this issue with quite a number of you for a while. I think I introduced this in our last session, and I'm just hoping and praying that you take your time and look into it. This is a question that I believe would appear in your orals because it's a matter that we're dealing with right now. I think most of us would tell you, Esbon, probably PLO, probably Angelo, that there's a difference right now. There are properties in Nairobi that have been gazetted for conversion, and the conversion that I'm talking about is the transitioning from the old or the manual regime where, for you to register a charge, you have to take it to the lands registry, it has to be stamped, or you have to do this. You have to do it manually, the way we are doing it right now. Now we're moving into the online system where you don't have to, you don't have to do all these things manually at lands registry, but you can do them at the comfort of your desk, just using your desktop. And this is done through the Ardhi platform. Now, I know there's conversion from public land, probably to, to private land. You've also talked about freehold to leasehold. I understand that, but there's this different conversion that you're talking about. And that's why I tried my best to talk about Ardhi, just so that I ensure that, I direct you towards the right direction. So this is different. I shared these notes with you last time, but I think I'll share them with you again. Now, just so that you notice, the conversion that I'm talking about, just to repeat, is the transitioning from the current regime of manual process of registering transactions in land to the use of the online system in dealing with land. What is the process? The first process is gazettement of the property in the Kenya Gazette for the purposes of conversion. Now, this process has started with the properties in Nairobi. If in a law firm, probably you'd have maybe seen this or heard about it. So it starts with gazettement of the property in the Kenya Gazette. Of course, after gazettement, for you to conduct this process through the Ardhi platform, you must be registered in the Ardhi platform. So you have to create an account in the Ardhi platform. So you have to create an Ardhi account. The advocate representing you should have an account on the Ardhi platform. Okay. Now, secondly, the advocate who is representing you will make an application for conversion. After they've made this application, you will consent to this application just by, appending a signature. It's a signature that you can do online using your mouse or using a pen, depending on the gadget that you're using. After appending your signature or putting a signature so that this process can proceed, we have the uploading of the title document on the Ardhi platform. So your advocate will upload the title, they'll scan it and upload it in the Ardhi platform for the purposes of verification. The lands registry will verify that particular title just to confirm that everything, in the three parts of a title, we have the property section, the proprietor section, the encumbrance section, everything recorded in those sections are correct. That's the purpose as to why they have to upload it before you receive this new title. So after uploading the title, we have verification of the title. After verification of title, we have surrender of the hard copy of the title to the lands registry. The advocate representing you is going to book for surrender of the title at the lands registry, and they're going to take this title manually or physically to the lands registry. That title, if verification was done and everything is okay, that title is going to be, I wouldn't say cancelled, but they're going to issue you with a new title, the converted title. This is going to be given to you by the lands registry. We discussed this process in our last meeting. Please, if maybe there's something that I've left out, you can listen to our last recording just to confirm. If you have any questions, again, my number is in the group. Our numbers are in the group. You can always reach out and ask me about it. Please, let's just try and learn through this. Let us try and understand the conversion process, because it's something that is happening right now. I want to believe these are questions that could appear in your orals exam. So please just try to understand the process and just try to understand that we have different types. I know you've talked about, we have public to private, we have leasehold to the one I'm talking about. And if you hear your panelists talking about the Ardhi platform, it's the one that I've just given you the process right now. So please just be careful with that. Nicole, is that okay?
Yes, it is.
Any questions for me?
I don't have any questions for you.
All right, Patrick, you can take it away.
Thank you, Daniel. Fantastic for having channeled that particular energy in terms of knowledge to at least notify not just Nicole, but the rest of those who've joined us this particular evening. So, well, Nicole, I think just to begin, I love your confidence. I mean, your balance is quite contagious. I mean, if Even if you didn't have content, at least I would know that you've presented yourself knowing very well that you will stand your ground. And that's a good thing to have, at least, appearing before a panel, composition of maybe perhaps persons who may not, whether or augur well with how composed or the kind of order someone exudes based on what kind of presentation they're making. So I think for me, your confidence, first of all, I think that stands out before I now got into the nitty-gritties of my questions. Well, I will only focus on, I think, two, because I asked you about the instances where court will strike out pleadings under Order 5113, while I was impressed by whatever response you gave me. And yeah, it's this is one question that we'll never miss, not just in oral exams, but even being given a problem question in the bar exams, and you're asked to find your way out of this particular question. Maybe their pleadings are quite defective, but they wouldn't give you that exact word of a defective, pleading, or a frivolous or a vexatious types of pleading. But there is something in that problem question, or in whatever question you will be asked during an oral exam, that will not ultimately lead you to deduce and find out that exactly this is a striking out, question. So yeah, so you need to think on your feet. So the responses, yeah, you gave, I think that's what I was looking for, and that was well done. So on probate, again, yes, do not be shy. I mean, not just directed towards you, but everyone here. Do not be shy. I mean, do not feel bad. There's no harm in saying that you have no idea about a given question. That way, it will have to save you time and even the panelists time, because I don't want you to fail. I'm trying to salvage whatever, that is left for you to find your footing again. So if you keep on answering a question wrongly and confidently, then it even erodes the trust of not just yourself, but even the panelists, because I'm certain you all have gotten to a point you even ask yourself, what exactly are you even saying? I mean, what the trail of thoughts have, totally been disorganized. I mean, everything has taken a different turn. So don't feel ashamed telling the panelists that you don't know exactly. Or you wouldn't mind, rather, to go and read more about whatever question they've asked you. So don't feel ashamed. And I'm happy that you told me, okay, fine, you would go ahead and read about this, because the responses you're giving me weren't exactly what I wanted. So even I would feel, and this is how the marks are awarded in orals. The lecturer or whoever is on the panel will just be sitting and, arms folded, and he's just there, she's just there looking at you. You're talking, you're submitting, but you have a forest of words, but with a matchstick of an idea, or a tree of an idea. So that's the best analogy I could give. So when you're not sure about a given question, just say, okay, fine, I wouldn't mind reading more about this, and tell the panel to lead you forth to a different question, so that you try and answer as much as possible on the questions that are left, instead of focusing on one question that will end up discrediting whatever you had even given earlier, right? So for the grant of letters of administration with well annexed, the kind of circumstances, I know there's so many grants, but my interest was focused on this. So the first instance, or the first circumstances under which an order will be made for grant of letters of administration with will annexed, is where the deceased actually left in a valid will, but there is no proving executor. That is to mean the will does not appoint an executor or an executrix if it were a woman. So the second circumstance is on where the executor appointed has predeceased the testator, or the executor has renounced the executorship. And then the third circumstances is where the executor or the executors or the executrix appointed has been cited, to take out the grant of probate and has failed to do so. So you can refer to Section 63 of the Law of Succession Act for your further reading. So those are some of the questions, especially if you appear before a panel of, Ruto or Anastasia. These are questions that wouldn't even miss. They're there by default. So the earlier you know them, the better. And then the other question that I asked you was on the difference between a judgment and a ruling. Yeah, I was impressed. Yeah, that I wouldn't deny. So what you extract from a ruling is an order, because it is pending determination of the final, suit. So these are just conservatory orders pending the, hearing of the entire, suit. So you only extract an order out of a ruling, and you extract decree out of a judgment. Fantastic. But I have no problem with that. Thank you. And then the difference as well, great, between the two. And during our time, we were asked actually to draft a ruling. That was the by exams. So at least most of you, or if not all of you, should learn how to draft a ruling. I mean, expect anything with CLA. Then the other question that I asked you is about what is it? Oh, review. Yeah. Justice Mugure Pandey, fantastic jurist. I mean, she's quite an inspiration. So the moment she declined to grant stay of proceedings, pending, whatever 7 to 14 days period that, the respondent advocates were asking to appeal, because the purpose of a stay is to more or less maintain the status quo as you try to seek more recourse, perhaps of or before a higher, court. So the moment she declined, and whether these are problem questions you should expect, current affairs, especially the Finance Act, please, and again I repeat, please at least have an idea, if not a whole content about it. So the moment Justice Mugure Pandey refused to grant stay of orders or declined, and then she was like, okay, fine, my orders will stand because there's nothing to grant, stay for her. If in any other thing, I will be validating an illegality that I've already given a ruling on. You see, so I didn't ask you why, the rationale for this, but the panel would ask you what is the rationale, why that stay was even declined. Okay, so have an open mind. Don't just be, confined within a particular setup or a mentality of how questions should be asked. No, so be an open book. So the moment she declined to grant those, stay proceedings, well, the only two recourse, actually low, just two. So I asked you, okay, fine, which are these two types of recourse that the respondents' advocates would have perhaps utilized to ensure their grievances are addressed? And I was impressed. You gave me two fantastic answers. You have review, you have appeal. Correct. I'll give you your marks. But again, I've asked you, okay, suppose they've chosen to review, okay, this particular ruling. And do they still have a chance to appeal? And then your answer was in affirmative, yes. Well, it's no. The moment you choose to review, then your right to appeal ceases. And you can't even review a review. The moment your review fails, that's it. So that's why the respondents' advocates were a little bit, hesitant to even, do an application for review, because they're like, you know what, if this fails here, we are done. But the moment you decide to appeal, you have the first appellate jurisdiction lies with the Court of Appeal, because the original jurisdiction is with the High Court. Okay, so of course the Court of Appeal will look at the facts and the law. But when you go to the Apex Court, that's the second jurisdiction of appeal. I hope you're following. the second jurisdiction of appeal, then there you only appeal on matters law. I hope you guys are getting what I'm saying. So it's an imbalance of of convenience based on the needs. I don't know, some will choose to go for review if it's a matter of urgency, but again, you weigh your client's case and say, okay, fine. If we choose to go for review, the same way in criminal procedure, of the criminal justice system and the criminal procedure code, that those provisions, and if you choose to review, well, there is revision rather in the criminal, aspect. So the moment you decide to go this route, then of course there is a period of 40 days about for your appeal. So you have to weigh both sides. But the right to appeal and the right to review, it's up to you as an advocate. But by law, you can't choose one. Like, you can have your cake and eat it. It doesn't happen that way. So you can appeal, Court of Appeal, you could go to the Supreme Court, and that's it. So you can't review a review. And the moment you choose to go the review way, you forget about the appeal. So you have to choose which is the lesser evil and which one will save not just you, but your client, some fees. So I think the notice of and memorandum of appeal, I think the Court of Appeal, whichever date they will be setting, but pending now the constitution of the 3-judge bench as advised by Mugure Thande being set up by the Chief Justice. Yeah, I mean, a panel member could even ask you why should the judge forward a file to the Chief Justice? I mean, what role does the Chief Justice play in constituting a bench? I think that's how questions come. So if you aren't prepared to understand exactly the open spectrum of how the legal, field works, then it will be hard for you to try and digest, decipher and comprehend exactly what it is you're doing before these panel members. So I think with that, generally, I'm impressed by your content, by your confidence, and I think you have the ability to do well. So again, I will be looking forward to welcoming you to the bar. I mean, you seem to have your act together, and I think the moment you incorporate, there's feedback and time to read more. I don't know what will stop you from getting 17 and above in the orals. I don't know, but for me, I think you have the potential to do one. So with that, ladies and gentlemen, I submit and I beg and implore to retreat to my peaceful haven. So back to you, Daniel or Husband. I think I'm done.
Thank you so much, Patrick, for those really informative review and comments. To Nicole.
Husband?
Yes, Daniel.
Yeah. Just a few, Nicole. I know probably I didn't give you any compliment because I was straight on, just giving you my what I think. Yes, I think as PLO has said, you have great confidence that I wouldn't want to crush. And I think even your verbal cues are so good. And I wish you all the best. And yes, your confidence is it's brilliant. All the best, Nicole.
Thank you to the both of you.
All right, thank you. Thank you, Nicole, and thank you, PLO and Daniel. Now we go into the next panel, shall be myself and Angelo again. Do you have any? Oh, I can see a volunteer already. Kibi.
Daniel, there was a question that maybe that I feel wasn't addressed by PLO on the issue of joint of parties. Did I miss it?
Okay. And Bernard, please.
Oh yeah.
Those are part of the issues that occur to me. Thank you.
Yeah. Thank you, Bernard. I was I was just about to respond on the chat box. But yeah, I mean, just to first respond to before I come to the joint of parties. Yes, the Court of Appeal will definitely hear both on matters of law and fact. I think it's the second appeal that doesn't include fact because you are arguing based on matters law. So now on the point of joinder and okay, fine. There was a word that Nicole mentioned, and I don't want to repeat it, but yes, for the joinder, for being joined, that's she got that right. But there's a difference now. What he was looking forward to is to join and or not to enjoin. So to enjoin with an A. So take this, I mean, from me, because even senior advocates keep on using wrong terms in practice. So to enjoin is to prohibit someone from doing something, whether by law or whatever principles they're in. But to join is to incorporate, to include the party who may not perhaps have been included from the onset when the suit was filed. So this will mean that they're either joined as an interested party, or if they are to be perhaps one of the main parties or respondents or petitioners, then again that's just to include them and be part of that particular suit. So what Nicole mentioned on or the kind of explanation on enjoining, well, that wasn't true, but at least I love that she tried. So to enjoin is just to prohibit. Okay, so it's not in any way connected to the parties being part of a given suit, but just to prohibit or injunct a party or just someone from either doing or failing to do something. Okay, yeah, so that's the difference I was looking for. But for the explanation she gave on joint of parties, yeah, that was right, she was correct, and I was impressed by that. Yeah, and then also in your criminal procedure, please, I know you've also learned about misjoint of counts. Yeah. Again, please refresh your memories. But thanks, Bernard. I think I've adequately responded to both of your concerns, haven't I?
You've done so. Thank you, PLO. I appreciate it.
Thank you, man. I mean, it was a pleasure doing this. Back to you, husband.
All right, thank you so much, PLO and Mr. Ayeko. Now, we have two people raised their hands. We have Kibi and we have Okumu Anyango. So, Angelo, maybe you can pick one of them so that we start. Kindly pick one. The next can have the next session.
Okay, thank you, Honorable Oko. Did you say Anyango and Kibi?
Yes, Anyango and Kibi.
Okay, we can, someone can unmute. Anyone, please, between the two of you?
Good evening, Angelo.
Yeah. Yes, who is that?
It's Kibi.
Okay, Leonard Kibi. Okay, thank you. Anyango, we will go with you in the next session. So I believe I will begin. Is that okay, Honorable Oko?
Very well in order.
All right. Kibi, what is the fourth arm of government?
The fourth arm of government is the controller of budgets and independent. No, is it the independent commissions? I'm not sure of the other part, but I'm sure of the controller of budgets.
Okay. My second question, therefore, is, Kibi, I would like you to answer this question.
Yes.
What is the constitution of the High Court? What is, when I say constitution, I also mean the composition. What is the composition of the Court of Appeal, and what is the composition of the Supreme Court?
Okay, so when you talk about the composition, it means when they are sitting on a matter.
Not necessarily not when they are sitting. Like composition, it means like when could you say that we have a Court of Appeal or we have a Supreme Court, or what is the minimum of judges that is supposed to be there for that particular court to operate?
Okay, thank you. So for the High Court, it is normally one judge, unless in the instance where the Chief Justice will appoint a panel of judges, a bench. Like in the case of the finance bill, they will appoint a panel. Now, when it comes,
I'm sorry, you are answering the quorum. I did not ask. My question is not with regards to quorum.
Maybe you can rephrase the question. I can get it.
What is the composition of the Court of Appeal? What is the composition of the High Court? And what is the composition of judges or composition of the Supreme Court?
Okay.
What should be the minimum number of judges that is supposed to be there for us to have a Supreme Court or the High Court or the Court of Appeal?
Okay, I can answer for the Supreme Court, but for the other two, I think I'll seek your guidance on the same, or I'll go and read on the same. So for the Supreme Court, for us to say that we have Supreme Court, it is when we have 7 judges sitting. We have a bench of 7 judges, which has the Chief Justice, the Deputy Chief Justice, and the other 5 judges.
Okay, very well. Can you please state for me what are the heads of this court that I have stated?
The names.
Yeah, the names of the heads of this particular courts.
Well, I guess, Angelo, for that, okay, of course, I'll just answer for the Supreme Court. For the other 2, I'll go and read on the same. So for the Supreme Court, we have the Chief Justice, Martha Koome, as the president of the Supreme Court. For the Court of Appeal and the High Court, I seek to go and read on the same.
Okay, very well. Second last, how do you become a member of a company?
Okay. Well, when one wants to become a member of a company, I think they make an application to the company. Can you just move to the next question?
Okay, very well. Okay, please state for me 4 forms of discrimination.
Okay, 4 forms of discrimination. The first one, I'll go with racial discrimination, which is given under Article 27 of the There's background noise. Okay, so the first one I said, it is these forms of discrimination are found under Article 27 of the Constitution. So I'd say discrimination based on gender, discrimination based on sex, discrimination based on race, and discrimination based on marital status.
Okay, thank you. That's all on my end. Esbon.
Well, thank you so much, Bwana Angelo. Now, Kibi.
Yes.
You have interacted with the laws, LSA, Law Succession Act. Okay.
Yes.
Now, Section 66 of the Act really provides for categories of persons who can apply for the grant. Would you kindly name name me 3 category of persons under, in fact, 4 persons under the section, that section who have the right to apply for the grant, and in what circumstance would that provision, section 6, be invoked?
Okay, I'd start with the last question you've asked. Section 66 will be applied whereby we do not have a test, where we have a will, but the will did not mention a testator. So now, no, an executor, sorry. So now those persons under section 66 will have to make an application to court to be made administrators of the estate. The second instance is whereby the will has been invalidated or has been revoked, or the deceased died intestate. So now the estate has to be administered, and the persons who are entitled to petition for letters of administration are the persons set under section 66, sorry. Also, another instance is whereby the testator, the executor, sorry, maybe has died or is not able to petition to propound the will. So those persons are entitled to petition for or to propound the will. So these persons under section 66 are: number 1, surviving spouse of the deceased; number 2 is persons who fall under the second category under section 29. These are maybe the parents, the children, the sisters, the brothers to the deceased. Number 3, we have the public trustee, and number 4, we have a creditor. Yeah, I am done, Esbon.
Okay, thank you. So another question is, you have been retained by a certain family which has a dispute in relation to succession. So from the set of facts, you realize that there are 2 categories of persons, rather two groups. There is a group A and group B of the same family. So now group A says that there is an existing will. They know that the deceased actually prepared a will, and yeah, that is what they believe. On the other hand, group B says that there is no will at all, that the deceased had in fact no intentions. So now you are put between to advise these members of the family. What shall be the way forward?
So to get your question correctly, there are 2 sides. One is claiming that there is a will, and the other side is claiming that there is no will. Is that the question?
Yes, yes.
Okay, so in that instance, if there is one side which is claiming that there is a will, I think the first thing we'll have to do is to go to court, because the court is the one that can make a determination as to whether because all parties first have to be heard. So for me, I'd say that I can advise them to go to court, and the parties which are claiming that there is a will to take the will to court, so that maybe the court can make a determination whether the will is valid or not, and because
Are you still on call?
Oh, sorry. Sorry, my point is that if there are 2 parties which are claiming that there's a will on, and there's another one which is saying that there's no will, my advice is for them to go to court with the will that the other party is alleging to be there, for the court to make a determination whether the will is valid or not. And also, these persons first should determine if they are, of course, the dependents in the estate of the deceased person. And maybe after making that determination is when I can know the way forward.
Right. The second last question to you, Kibi, is you understand the ID parade?
Yes.
So maybe just briefly tell me, what is an ID parade?
Okay, an identification parade is a procedure that is undertaken whereby the witness or the complainant is identifying the suspect, and in this instance, the victim does not know the person who committed the offense against them. So this identification parade is given as was provided in the case of Republic versus Mwango, and the court stated that an identification parade happens when the suspect is not known to the victim or the witness. If they are known to the victim or the witness, then this will become a recognition.
So the plan was tena tukiongea
Okay, sorry. Had you finished responding to the question?
Yes, I am done. I am done.
Okay, now you answer. There's a follow-up question I want you to maybe answer on the identification parade. So you've really given the context of what an ID parade is. So a follow-up question is, what are some of the grounds under which, or some of the exemptions of undertaking an ID parade?
Okay. First, I'd say an ID parade, the procedure is provided for under the National Police Standing Orders. The instance whereby
just tell me the exemptions direct.
Okay, so I was getting to that, to the exemption. So the first exemption is when the suspect refuses to undertake the ID parade. The other instance is when the victim knows or recognizes the suspect. Those are the only two exemptions that I know.
Right, fair, quite okay. So the last question to you is, you understand the third party proceedings?
Yes.
If you look at Order 1 Rule 15, you really get the third party proceedings. So under that provision, what are these two grounds under which a person will be joined in a suit as a third party?
Okay, so the first ground is when the defendant is claiming that they are seeking contribution from another person who is not yet a party to the suit. So if that person was supposed to bear liability, then the third party will be brought in. Another instance is whereby the third party, there is need to divide liability between the defendant and the third party. So that third party is supposed to bear liability with the defendant will be brought in.
All right, thank you. I think that was it. I'll give Angelo a chance to give you the feedback and the review of the questions he asked you. Angelo, kindly.
Okay, thank you, Esbon. Kibi, I would say you really did well. Maybe you did not anticipate that I would ask questions like that, because sometimes you may think that maybe no one would be interested to ask you some of those questions. So anyway, let me go into it. So a person will ask you to give a constitution of the court or composition of the court, okay? So you see, for example, the High Court, we have that Act of Parliament that was enacted in 2015. It is called the High Court into bracket Organization and Administration Act of 2015. So there it has provided the number of judges that the High Court should have. okay, or for time being. Okay, so number of judges prescribed by an act of parliament. So, and this particular court is headed by a principal judge elected by judges of that particular court. So you can look at Article 165(1) of the Constitution of Kenya 2010. So if you look at the Court of Appeal, and you see there, I have not given you any number because there might be even over 200 of them. Okay, but for the Court of Appeal, for us to say that we have a Court of Appeal, we must have not fewer than 12 judges as prescribed by an act of parliament. Okay, and you see this particular court is headed by a president who is elected by the judges of that particular court. Okay, then we have the Supreme Court, which is for us to say that we really have a Supreme Court, there must be not less than 5 judges. Okay, we know that there should be maximum of 7 and not less than 5 judges. Okay, so in this regard, this court is headed by the Chief Justice. So when now I proceed for you to tell me who is the head of this particular court, of course you gave me Chief Justice, our ladyship, the Honorable the Chief Justice, that is Martha Koome. We have Justice, is it Musinda, that is of the Court of Appeal. And then we have this famous judge. I don't know, he actually has about 5 names. Okay, is he Ogola or is who? You can actually check. He was recently elected. Was it this year or last year? The guy have a lot of names, but you can choose one because he's one of the famous judges. And when I talk about the 4th arm of government, I'm referring to the independent offices and commissions. Okay, like the Office of the Director of Public Prosecution, that is an independent office. Okay, it is not under the control of the president or the executive for that matter. We have the Independent Electoral and Boundaries Commission, that is an independent commission. The commissioners don't serve at the pleasure of the president. Okay, then the other one, another example is Ethics and Anti-Corruption Commission. That is an independent commission. They don't serve under the pleasure of who? Of the president. So, and when I talk about the forms of discrimination, we have about 4. We have direct discrimination, indirect discrimination, multiple discrimination. We have equal opportunity and differential treatment. Okay, these are things that you can easily now go and Google, say that you can see what is direct discrimination, what is indirect discrimination, multiple discrimination, and equal opportunity and differential treatment. So you realize that in the legal practice and management, that is LPM, we have that topic of discrimination. We have another one of sexual harassment. So sometimes the questions will not only revolve around civil litigation, criminal litigation, so they go further into LPM and also legal writing and drafting. I don't know if I asked you another question or that was all on my end.
There is a question where you asked me how one joins a company.
Oh, yeah. That was a tricky one. Okay. But one could join a company. That is, one can become a member when you subscribe to the memorandum of association. Or nowadays, you can just say when you subscribe to the constitution of the company, because you see the Companies Act that we have in place right now, there is no that much distinction. It is like we just say that the constitution of the company. But when you subscribe to the memorandum, that is a memorandum of association, and secondly, when your name is entered into the register of companies, so that is how you become a member of a company. Is that okay?
Yes, thank you.
All right, thank you so much. Honorable Esbon MC Oko, please take it away.
Thank you so much, Bwana Angelo. So now, Kibi, the principal judge that Angelo was referring to is actually Mr. Eric Kennedy Okumu Ogola. You can check that later. To my questions I asked, You really did quite well. I'm really impressed. So the question about ID parade, you really answered it so well. The only challenge was the exemptions. You, I think, not able to get the whole exemptions. Maybe you can have a look at that. But remember, in ID parade, some of the checklist is like before they undertake an ID parade. Of course, they need to have the ones we call the feelers. The 8 feelers. These persons who resemble the suspect. So if you are not able to get the 8 feelers, then you cannot undertake an ID parade. So that is an exemption. The second one is it's in a case that you did mention, actually, Republic versus I don't know, son of Mana, someone, Mwago son of Mana. Yes, Mwago son of Mana. So that is the case where it was established that where a person is actually known to the person, the person is known, then identification should not happen, because that will now not be an ID parade, but it will just be a matter of exemption. Like, for example, if I'm asked to identify you, I'll say that I cannot undertake an ID where you're a suspect because I know you to be a matter of a recognition. Then I think you also have you got it where the accused, the suspect has not consented, because they have to consent to this exercise so that you're not just subjecting to an exercise that they don't know the effect. So those are some of the grounds. You can have a look at it. Then I remember when I asked you about the exemption, you started speaking about the legal provisions of ID parade, and I stopped you. The reason I stopped you because the first question that arose to the follow-up question of exemption was, speak to me about an ID parade. So I expected you to grab that chance, give me the legal provisions of what an ID is, like where is it provided for, and just talk, in fact, everything. If you're given that chance, you can speak everything until, even if they had a follow-up question, you are answering in it. So that was a chance. I hope so next time you'll utilize it, but you did well on that question. Then on third party proceedings, you really did it well. The two grounds under the 1 Rule 15, that you are being joined as a third party through the third party notice, you must know it as by way of contribution or indemnity. Like, for example, an insurance company, you say that because you insured your car involved in an accident, they are supposed to indemnify you. Or because someone contributed, let's, for example, in an accident, a certain car contributed to the happening of that accident, you join that person to a suit so that they can actually contribute to whatever liability the court is going to declare. Then you're supposed to know from now that Rule 15 to Rule 20 or Rule 21, knowing from the perspective of an individual and the government, what happens or what is the procedure for a third party notice to the government. Under what circumstance can you give a third party notice to the government and to the individual? And to the government is very specific. You need to like get the wording. You need to get the wording from the CPR. For you to give the government a third party notice, you can't just proceed them. You must give there has to be sufficient reason as to why you're giving that third party. Then you proceed with that same order or same rule. They'll give you the procedure. If the government fails, if the individual fails, how do you apply for the default judgment by either? And then if someone does not participate in that third party proceeding, despite sufficient service upon them, what happens if now a judgment has been given against the defendant? What recourse does the defendant has, and what liability, to what extent will that third party be liable in respect to the judgment which has been issued? So you can go look about it on the third party proceeding. Then I also asked you about the section 66 of the LSA. I think you are really you really answered it so well. I associate myself with the response. I think it was very conclusive. Then another question was the question on I asked you I gave you a scenario where there's some family members, certain family members hold opinions that there exists a will, Another one hold opinion that there is no will. So now you're an advocate. So you need to know that, of course, that is just an example or a question I asked you about the citation. So you need to get to know the types of citations and explanation. What are they? So that if you're given a circumstance or a scenario, you get to understand the question is asking about citation. So the answer I was waiting to hear is it is an aspect of citation. So that this person or this group of persons who are saying that they exist a will are supposed to be cited so that they explain. It's a will to propound an existence of a will. That if you say the will exists, you shall be cited so that you explain the existence. So you can go read that section, I think 21 of the Act now, not rules, to know different types of citation. For example, citation to take out, citation to renounce, citation to propound the existence of a will, and to know like under what circumstance can they arise. So for the one I asked you, it was the citation so that you propound existence of the will you claim to be. So that was, I don't know if you have a question for myself.
I don't have a question. Thank you for the response and for the response and the guidance.
Okay, thank you so much. On behalf of Angela, we wish you the very best and you will do well. Now, there was a person, I think it was Akumu. No, it was Okumu.
Just a follow-up. I also have a follow-up question.
Well, a follow-up question. Then will you volunteer for the next session, Bwana Ayeko?
I'm not in a place I'm comfortable, but I will be moving to a comfortable place. Hopefully, I can pick up a slot before the end of the night. But for now, yes. But for now,
you are a comfortable question.
Yes, where I am actually, I can ask a question because I've just excused myself briefly.
Okay.
Yes, but since I need 10 minutes, I would want a place that I can answer without disturbance. So here is my question. How does someone become a shareholder? How does someone become a member of a company? Is it similar to how does someone become a shareholder of a company? Number one. Number two, in identification parade, they say that we identify the person we know and we recognize the person we didn't know. Could you kindly comment on that mantra? Thank you.
Sorry. Will you kindly repeat the second question, kindly?
Thank you. On identification parade, they say you identify the person you know and you recognize the person you didn't know. Can you comment on that mantra with regard to ID parades? Thank you.
Okay, now briefly, let me start with the second question, then the first question, then I'll yield it back to Angelo to pronounce himself on the first question. So now on ID parade, of course, the first thing you're supposed to understand is the objective. What is the objective of an ID parade? We do ID parade because an offense has been done by someone who is not known to anyone. But then there's a suspect now in question. So people come out so that we get to identify the person, the doer of this offense or the committer of this crime, so that if you have to charge, we are charging the rightful person. So it means that none of us know. We just know a person by the description. This is how they walk. This is how they appear in the face, their heads, their hair, their appearance, and whatnot. So you're trying to identify in terms of the physical appearance. Usually it's a physical appearance of a person. So it means that this is a person who should not be known to you. So that if, for example, let's say, God forbid, it's your aunt who committed a certain offense, and you clearly know it's your aunt who committed a certain offense, and now the police want to undertake an ID parade. You realize it will just be a waste of time to do the ID parade because you already know the person who committed the offense and you know you are aunt. So you just go and say, it is this one. So that will not be an identification parade, but it will be a recognition. You are recognizing, just recognizing this is the person who committed, and that can maybe fairly happen in docs. Like if you've attended the criminal proceedings in court, the person will be asked, can you see the person? they will say, yes, I can see. So that is just like you're just like pointing out, recognizing the person, because you know he's the one or she's the one who committed the offense. So, but the ID parade, you don't know. You're just trying to give out the features from the appearance of that person who committed the offense had. So that is why they say you should not be knowing the person before, or rather in undertaking this activity. Is that clear?
Very clear. Thank you. Thank you so much.
I also
Now,
had a follow-up kindly.
Just a minute. He had two questions. Huh? So the second question, before I can see Daniel want to speak, but before Daniel, maybe briefly.
Hesbon,
Yes,
can
Daniel?
these guys at least carry their hands so that we have some order? I think it's only fair.
All right. Okay, thank you. So I think that is clear. Guys, if you have anything, just raise your hand. I'll see it on my side. So now, the second question, rather, which came as the first question was, how do you become a shareholder and how do you become a member of the company? So you get to understand that the shareholding is different from the membership of the company. So that if you go to the records of the company and you're doing a search, for example, if you go to the records of the company register, you'll see the membership of the company. You see this person ascribed to the memorandum of association of a certain company. There's a certain example, like for example, if like for example, you have an account with a bank. So if the bank want to close, will they notify you? Maybe they won't notify you. You have shares, but they won't notify you. But they will have to notify their members. So that is example of the difference between shareholding and membership. So how do you become a shareholder? You become a shareholder of a company if you buy a share, and you know, for example, how you can buy a share. They usually advertise, for example, if shares are advertised publicly, then you can engage. That is for the public companies. Then for membership, it's a bit advanced. Like for example, you can easily get ascribed or subscribe to the membership through allotment. Like if you are allotted shares, you can be entitled to the membership. Your name can be entered in the register as a member of the company. Then you now subscribe. Or there could be other ways of subscribing to the membership, or rather subscribing to the memorandum. So if you subscribe to the memorandum of association, you become the member of the company. But if you just buy the share, you just become a mere shareholder. I hope so that is okay, but I will request Angelo, maybe being the custodian of the question, to maybe pronounce himself on the same.
Esbon, I have nothing useful to add. I think that is in order.
Thank you so much. I can't see any hand raised in terms of a follow-up question, unless somebody can. Oh, I can see George.
Esbon, we have Onyango. We have
Okay.
Onyango, but maybe you can ask this question after the end of our session. Okay, because we are running out of time.
Okay, so George, kindly just hold on, then you'll ask a question after the end of the session, kindly. I hope so you'll not forget about it. So we have Anyango Okumu, Anyango Okumu, who's been waiting, and I request that Daniel and Lavins proceed with her. Back to you.
All right. PLO, would you like to start, or I can begin?
Well, if we were in a courtroom, I think I will begin based on seniority. But for this instance, I'd like you to proceed.
Okay. All right. Anyango, kindly just introduce yourself.
So actually it's Onyango Akumu. Okay. My name is Onyango Akumu and I'm a member of Class D. And I'm a member of Class D, Farm 16.
All right, we'll go right into it. Onyango, what was the judgment in Force versus Habuto?
So the judgment in Force versus Harbotol, it was basically talking about derivative claims, and the judgment actually brought about rules that became landmark cases, became landmark rules in company law. And one of the rule is appropriate plaintiff rule. And this appropriate plaintiff rule is to the effect that the proper plaintiff to sue when a company is aggrieved, it's actually the company itself that bears the honors to sue in its own name. But at the moment, I can't remember the other rule, but there was another rule that they pronounced themselves to. Thank you.
So at what point would we say that it's the company that is suing and not someone else?
So the point at which we can say that a company is suing, maybe it's when when the company has been aggrieved by a third party, and by a third party I mean a person who maybe has not subscribed to the articles of association of the company. It might be maybe another company that contracted with this company, and now the other company acted in breach, or a certain person, not precisely a member of the company, has done something that has aggrieved the company. So in such an instance, the company will move the court in its own name. But in an instance where maybe there is an issue, maybe the minority shareholders feel like the majority shareholders maybe they are infringing on their rights, then in such a case, then the minority shareholder can move the court on behalf of the company. Yes.
While the minority shareholder is moving to court on behalf of the company, how do we call that particular action?
It's called a derivative action.
So is it proper to argue that derivative action is an exception to the holding in Force versus Harbotol?
Yes, it is an exception. It is an exception, and I'll actually make reference to the proper plaintiff rule, because a derivative action it's divergent to the proper plaintiff rule in that a minority shareholder, or rather a shareholder, can move the court on behalf of the company. But the proper plaintiff rule actually it requires that the company is the one that can sue in its own name. So a derivative action is rightly an exception to the rule in Force versus Harbotol.
Okay, all right. On to our next question. What are the different types of companies? And please, when it comes to answering this question, just tell me the characteristics of this company.
So the different type of companies, actually, when you're talking about the characterization of companies, we need to take into consideration the two aspects that actually govern the characterization of companies. One of them will be the public and private company, and then the other one will be limited and unlimited companies, because these are actually what a company is. So a public company, so one of the types of company is a public company, and when it comes to a public company, this is a company that has I'll talk of it as regards the membership, and under the membership, a public company rather, requires that the members should be not less than 2, and to infinity. It can go to the maximum that it can go to. And then a private company, it's the one that there can be 1 member, and then the maximum number of members is 50. And I'll also speak to the transferability of shares. And under the transferability of shares, you'll find that in a public company, then shares can be transferred. But in a private company, we cannot say that shares cannot necessarily be transferred, but they can be transferred, but then the members of the company they have a preemptive right such that when a member of the company intends to transfer their shares, then they need to consult the members of the company so that they can exercise their preemptive right before transferring these shares. And then I'll also speak to the issuance of the invitation to the public to subscribe to the shares. So in a public company, the prospectus can be issued to the public so that they can subscribe to their shares. But in a private company, there is no instance where prospectus can be issued. So there is no invitation to the public to subscribe to the shares. Thank you.
All right, my last question. What are the defenses to a takeover? What are the defenses to a takeover?
So we haven't covered mergers and acquisitions, but maybe I can give it a try. So the defenses to a takeover, maybe one of them would be.
It's okay. It's okay, Onyango. Let me give you another question, yeah?
Okay.
All right. And this is again my last question. What are the remedies to a chargee where the chargeur has defaulted in their duties? What are the remedies to a chargee where the chargeur has defaulted in their duties?
So the remedies to a chargee when the chargeur has defaulted their duties, one of them would be they can exercise there's the right to lien. So they can exercise the right to lien. There's also the power of sale, and so they can also exercise a power of sale, and they can also appoint a receiver, and they can also opt to lease out the property when the chargee has defaulted. Thank you.
All right, thank you. Thank you. Maybe PLO can take it away.
Thank you. Who is on the hot soup? Is your name?
My name is Onyango Akumu.
All right. How are you, Mr. Onyango? You good?
I'm good.
You nervous?
To some extent, yes.
Right, good. So here we go. When you look at Article 162, sub-Article 2 and paragraph A and B of our Constitution, it establishes courts of the same status as the High Court, which is established under Article 165 of our Constitution 2010. So my question is this, very simple. It's a yes or no answer. Can a judge of the special courts and with the same status of the High Court, and I believe you know what kind of courts I'm talking about, can those judges sit in a normal High Court established under Article 165 of our Constitution? So it's a yes or no answer. I don't want an explanation.
I'd say no.
Are you sure?
With the knowledge that I have, yes.
All right. Fair enough. My next question, what are the modes of terminating proceedings? Just two.
So the modes of terminating proceedings, they can be striking out, and also once a judgment has been entered, then the suit will be terminated.
Okay. So assume I'm a defendant in a suit you filed against me. So assumed I'm nowhere to be found. Okay. So how do you effect service?
So in such a case, then I'll opt for a substituted service. So basically a substituted service is divergent to how normal service is actually effected. So in that case, then I would move the court to be allowed to serve you, to be allowed to serve you with a substituted service. So maybe if you are nowhere to be seen, then maybe the service will be to the effect that it can be sent. If your address is known, then it can maybe under your door, something like that. Or maybe if you work in a certain company, then it can be given to maybe the company secretary, so that once you're seen, then they can serve you. Or maybe in the courtroom, then it can be placed in a public place where you can see. So basically, a substituted service will be entered in that case.
All right. So assume again, out of the country, well, I'm not, within the jurisdiction where the suit has been filed. So I am out of the country. Perhaps I'm in Turkey, I'm in Switzerland, I'm in, Australia, wherever I am. So how do you effect service? And by what kind of an application?
So in that case, then the application will be chamber summons ex parte, and the service will be effected. Maybe I can't speak to how the service will be effected, but the applications will be a chamber summons ex parte.
So you've mentioned the chamber summons ex parte, and my question is very simple, just a follow-up question. Okay, so is a CS a standalone application?
Is a CS
a standalone application? Does it stand on 1 feet? I mean,
No.
1 foot rather, or is it supported by both feet, or any? I mean, any or either will just do.
So basically, as a preliminary, I would say that all applications are not stand-alone because they ought to be supported by an affidavit. So I would say it's not a standalone application. There needs to be an affidavit that supports the application.
Okay, so again, just on the same particular wavelength, while all applications are all standalone applications, fantastic. That's okay. Yeah, so my question now, just it ought to have preceded exactly what I asked. So this particular question is, how do you apply to the court through this particular CS? I mean, do you just wake up and, okay, fine, the court is here, I need to file this application? Do you just do that out of the blues? Or what
No.
precedes, you filing this application?
So because, an application is not a standalone application. So you need to actually file the relevant pleading. So maybe, for example, it's a plaint. So you need to file a plaint to institute the suit. And under the plaint,
Mr. Onyango, I've taken cognizance of all that. Assume the way I will say in appeal that we assume all facts are the same, so we only plead the law. So the same way I would say, okay, fine, I assume whatever you're saying is true. That is common knowledge. But now I'm asking you, you're here trying to file a CS. So what precedes you filing a CS, such as, in this particular scenario? I mean, is there any way you will invoke the court for the court to grant you audience to file this application? Well, I've given you all the clues that I could have. So if you can't answer the same, you can let me know so I proceed to the next question.
So maybe you can.
Do we pass?
Let's pass at the moment.
Fair enough. All right. Assume again, I'm a foreigner. So how do you even serve me? So while I am now not out of the country, well, of course, I mean, I could be a foreigner out of the country, within the country. So assume I'm not out of the country, also nowhere to be found, but hey, I'm a foreigner now. So how do you even serve me?
You are a foreigner now, so
Yes. How do you effect service?
So in that case, then I would go under the substituted service, but then there ought to be the aspect of resealing, because if the service has been sealed by maybe the High Court in our jurisdiction, then for the service to be effected in the country that you are in, it ought to be resealed. By resealing, then it ought to be recognized by the courts of competent jurisdiction in that country that you are in, so that I can effect the service. So I'll actually go for substituted service, but then it ought to be sealed in this country, Kenya, and then it ought to be resealed in the jurisdiction that you are in, then I'll effect the service after the resealing.
All right, fair enough. So my follow-up question, do you think, so you either answer in affirmative or lack thereof. So do you think it is trite law that if you were to effect, service to me as a foreigner or any other foreigner, do you think it is trite law that the course of action against that particular foreigner must have risen or arisen in the country where that particular suit was filed? And if I, as the foreigner, is lawfully present in that particular jurisdiction, which is Kenya, and is it also on my own volition that I'm present in that particular country? So is it trite law or it's not? So it's a yes or no question.
So it is trite law. I'd say it is trite.
So yes, so that's in affirmative?
Yes, in the affirmative.
Fantastic. So my final question. Okay, so assume I'm a sojourner again in this particular scenario. How do you effect the service?
So when you're a soldier, then I don't think I will effect service because soldiers are subject to the court martial. So in that case, then I don't think there is any service that is to be effected against a soldier.
Are you sure?
Yes, I am.
Are you sure? I'll ask again for the third time. This is the second time. Are you sure?
So to the extent that there is a court martial, then I would say that they're subject to the court martial. So if maybe I had moved a court martial, then if the service is if I've moved a court martial to get the service to enter against a soldier, then I would say then service will be effected if it's coming from a court martial.
Well, all right. Thanks for your response. I think husband, I'll wrap it up and give our feedback.
Okay, thank you so much. Thank you so much, PLO. So now PLO and Daniel will each have 2 minutes to just give a very brief feedback because we still have another session, another round. So kindly keep it at 2 minutes, kindly, for the just quick feedback. Just give them pointers on the directions, kindly. Thanks.
All right, I'll go fast. Now, Onyango, Akumu, I think your answers in relation to the remedies available to HRG were correct. Maybe you can just add the fact that they can also sue for payment. Derivative action, you got it correctly. Types of companies, yes, section 6, 7, 8, and I think 9 of the Companies Act. Force versus habitur, I think that's why we had a bit of a problem. When you talked about, you kept saying force versus habitur has different rules and the rule is proper plaintiff, but you couldn't really explain this proper plaintiff, what it means exactly. And I think you can also attest to that. Now, when you talk about the proper plaintiff, meaning that it's the court, it's the company that must bring this claim, not anyone else. Now, for us to say, for example, that a company has given instructions to a lawyer, or for us to say that a company has made a decision, for us to say that a company has spoken, for us to say that a company has decided to buy something, or a company has decided to file a case against someone, then there must have been a decision. There must have been a decision. Board resolution probably must be present. Now, whether decision is made or not depends on the articles of association of the company. In most instances, you'll realize that it's either 50 plus 1%, or we're talking about 75%, which is a special resolution, meaning for us to have a decision, for us to say the company is doing something, then that is embedded or impegged on whether there was a decision. So when you talk about the proper plaintiff rule, we are saying we must have a majority for us to say that a company is suing. We must have a majority vote, a majority decision to say that a company is suing. So where we don't have a majority decision, then the company is not suing. Some people have just decided to go to court and claim that the company is suing because the company has not decided to sue. So first, Mr. Sabuto was saying that we must have this majority decision for us to have a proper plaintiff, for us to say that the company is suing. Why? For us to say that the company is suing, the company must make a decision. For a company to make a decision, we must have a majority decision. Now, derivative action, as stated by yourself correctly, now has come in as a remedy, and it's saying that even the minority can sue in instances where they have formidable and reasonable grounds that maybe the majority have done this, they don't agree with it, the interest of the company needs to be protected here and there, then they'd have the right to bring this to court. And in this instance, we won't look at the majority decision, but we'll say that these guys have a point and we can listen to them. Again, this is in the Companies Act 2015. That's it. Thank you. Maybe PLO.
Quick one, just briefly again for the sake of time. Yes, no, rather no. A judge of special courts with the same status as a court under 165 of our Constitution can never sit there. You can look at the case of Oscar Angote at your free time, and you will gather brief gist of it all. And the other issues that was of concern, one, how do you terminate proceedings? Simple. I mean, striking out and the summary judgment. I didn't want so much explanation, but just those two. That if I'm nowhere to be found, how do you effect service? Yeah, I mean, well, you got that right. But again, you have to, the court itself has to seize itself with that particular jurisdiction and may on application actually order those particular summons to be served either by affixing a copy thereof in some conspicuous place in the courthouse and also upon conspicuous part of the house, or if any, in which myself as that defendant was last known to have resided or carried on business or even personally worked for gain in such a manner that the court may deem or think fit. The other issue is if I'm out of the country, how do you effect service? Well, here you can serve me outside, the jurisdiction only after a particular court grants you permission to do so. So you will apply to the court for leave to serve outside the jurisdiction of the court, and application is by way of CR supported by an affidavit. So the answer I needed here, Mr. Nyango, was leave of court. That's what I needed. Okay. And then normally, of course, you will tell the court the mode of service again that you would want to use. So this differs even in practice. And then how do you serve me as a foreigner? Well, service can as well be ordered by the High Court anywhere in the Commonwealth. The key word here is the Commonwealth, and you understand the Commonwealth of Nations. So you can serve me as a foreigner within Kenya, provided that course of action. That's why I asked you, is it trite law? So one thing, you can only serve me as a foreigner if that course of action against me arose in the country, which is Kenya, and if myself is lawfully in Kenya, and then lastly, on my own volition. So that is why I asked you, is it trite law for this to happen? And you have the answers. The other question that I asked you, where I'm a soldier, okay? So there's a difference between being a soldier and being an officer. So where myself, I'm a defendant, as a defendant, I'm a soldier, but I'm not an officer, then the court shall send the summons for service to my commanding officers. That's the answer I needed. To my commanding officer, together with a copy to be retained by myself as the defendant. So forget about the court, martials. I mean, there are matters at the end of the day, court martials and other special courts. Those are special courts that Parliament, would set up in accordance with the provisions of the Constitution. But remember, any matter touching on the interpretation of the Constitution has a High Court as a supervisory jurisdictional court against all other subordinate courts. So I will call a court martial a subordinate court, okay? Because there's so many special courts that deal with different jurisdictional questions. So if I'm a defendant and I'm a soldier, but I'm not an officer, the court shall send that, or those summons for service to my commanding officer, and then together with the copy to be returned by myself, again for ease of response. I think those are the questions I asked, and yeah, you at least you tried, and I think keep on polishing up. Yeah. So, but the case on whether a judge of an ELC or ELRC could sit in a high court, Oscar Ngotti, I think it was Carissa Chengo, yeah. That was the case. I mean, or the locus classicus on how you will understand why a judge of a special court such as ELC or ELRC cannot sit on a normal court established under Article 165 of the Constitution. What precedes the CS, the leave? That's what I needed, Mr. Onyango, to tell me. So with that, ladies and gentlemen, I think back to you, husband. Perhaps for the last round, I guess, of questions and the feedback. Yeah, so you could kindly advise. Thanks.
Okay, thank you so much, Patrick. So now we need the last volunteer to do the last round of orals of the oral session. The last volunteer. I don't know if Bernard, have you positioned yourself in a place you can, or Angelo, you have a lucky winner? I heard you have proposed.
I think I can go.
I don't
I
have
can
a
go.
lucky winner.
Okay, we have a volunteer in the name of.
In the name of who?
In the name of Bernard.
Okay,
Okay.
that is okay. We can proceed with the Yeko. Council,
Okay.
can you proceed?
Okay. Bernard, I'm going to be quick.
Yes.
Okay, please let me start. The first question is, please explain to me what is McNaughton rule?
Thank you. My name is Bernard. I'm in class G. And McNaughton's rule is the test that was brought forward from McNaughton's case, where the judges opined that for one to stand trial in a murder case, they must be tested for sanity. And in this case, anyone who is accused of murder must be tested for sanity before they can stand trial. Thank you.
Very well. Quickly, at the same time, please differentiate for me between murder and manslaughter.
Murder, I can say murder is under section 201 of the Penal Code, if I'm not wrong. And murder is basically the act the act that has the mens rea, the malice aforethought that leads to death of a person, while manslaughter is the act that leads to murder, but one that does not meet the threshold of mens rea or does not have the mens rea in it. Thank you.
Okay, very quickly at the same time, what is a voir dire and how is it applied?
Voir dire, I can say it's it is used in trial where the judge can decide on who is saying probably who is saying the truth. Actually, it's a French word that means speaking the truth, and it arises out of oral submissions or testaments that are given by witnesses. Thank you.
All right, quickly, at the same time, this one I would have given you a scenario question, but because time is limited, please, what is your understanding of cab rank rule, and what are the exceptions, if any?
Cab rank rule is a principle that arose from the UK, and it basically means that one cannot decide or one cannot choose the type of clients that they need to represent. And it arises, it compels every advocate of the High Court, in this case Kenya, to take up any brief, regardless of anything that surrounds that brief. But it has its own exemption, one of them being issues of conflict of interest, where you have a conflict of interest, probably that arises from either from representation or any other issue, then you will then have to turn down that brief. The other thing would be maybe on ethical grounds. We have people perhaps who may not be comfortable to represent a certain client based on some ethical issues. And lastly, where there is a professional issues, professional challenges that may inhibit an advocate from taking up that matter. Thank you.
Are you sure about the ethical issues that you have just mentioned?
Yes, I'm sure about the ethical issues, and I'm sure about the ethical issues, only that they could vary from case to case. Thank you.
Okay, interesting. Finally, what is the ejusdem generis rule?
Pardon?
What is the ejusdem generis rule?
Ejusdem generis rule. I think it's a Latin word, and generis means from sui generis, of different kind. But on this one, I think it's of the same kind, and it means that generally, if there are any issues that if there are any cases that have the same kind, then they can be dealt with from a class or a specific kind of related cause of action. Thank you.
Okay, thank you so much. I like that last answer. Anyway, Esbon, proceed, please. Thank you.
Thank you so much, Justice Angelo. Now, Mr. Ayeko, how are you?
I'm fine, thank you.
Right. So now, you realize that Ayeko is actually not your name, and you want to remove this Ayeko from your details. Please proceed.
Yes, if Ayeko is not my name, I will go for a deed of change of name, a deed of poll, and I will change my name, but I will also look at, I will file a document. I'll go to the advocate and file a deed of poll to change my name. Thank you.
Right. Fair enough. Now, who is your trial advocacy lecturer?
Wow, thank you. My trial advocacy lecturer is Dr. Eric Kibet.
Dr. Eric Kibet.
Yes.
Very well. There are these two cases that you use in doing a trial advocacy. The one Desmond Peters case, and the other one is
Desmond Peter. This is the City Hopper versus Desmond Peters, and then the Mueni case.
What is the full name of the case?
The one from Mueni case.
Yes. What is the full name?
The Mueni case, I think, is it Faith Mueni? I just know it as the Mueni case, which was on, I think, on a matter of probate.
All right, that is okay. Now, you are an advocate of the High Court of Kenya, and you've been instructed, and the instruction is clear. You are representing, you are for the prosecution in the Desmond Peter case. So your task is to give an opening statement. So, assuming you're appearing before a High Court with a quorum of 2 lady justices and 1 judge gent, please introduce yourself and give a very brief but concise opening statement.
Thank you, my lords. Thank you, my lords and my ladyship. My name is Bernard Ayeko, holding brief for Desmond Peters. My lords, I'm looking at Article 53 of the Constitution, and I feel that my client has been prejudiced by the submissions that have been given here. Again, my lords and my ladyship, as I look at the United Nations Charter on the rights of children, I feel that what the plaintiff have put forward is against the provisions of not just our Constitution but the United Nations Charter on the rights of children. And I think I would request that the court strikes off this suit, and with that, they can strike off this suit together with the cost. Thank you, my lords and my lordship.
Right, very well. Maybe in the interest of time, I'll ask you the last question. Kindly, will you will it not distinguish, but will you maybe make me understand the meaning of this doctrine, the doctrine of ademption?
The doctrine of ademption, I think, is in the law of it's in conveyancing, and it means a property. Sorry, a doctrine of ademption is on matters of succession, which may have a bearing on issues of testamentary gifts that are in form of assets that no longer exist at the time of the death of the deceased. And what usually happens is that these assets may, in one way or another, probably have morphed in terms of their status to an extent that they cannot be devolved to those who have been mentioned in the will. And some of these assets could be perhaps by virtue of the form that they are in. And I can easily look at perhaps maybe in assets like stocks in equity markets, where they have you could, at the time of bequeathing, probably quote my stocks in this company amounting to 1 million, but at the time of valuation and upon death, because of the way the stock market, they are valued, the stocks may not be amounting to 1 million. Probably they could be half that amount by virtue of the the market forces. I think that's how I can explain it. Thank you.
You think, or that is how you'll explain it?
That's how I would explain it. I would explain it as an advocate of the High Court. Thank you.
Okay, okay. Now, the last question, I'll just maybe need your 30 seconds in answering this one. And because we're approaching midnight, let me now ask you this one. What is a midnight clause?
A midnight clause?
Yes.
A midnight closet or a midnight clause?
Okay, in drafting a contract, what is a midnight clause?
I think in drafting a midnight clause, and as rightfully as you've put it, it's a contract that is drafted when midnight approaches, and what it means basically is that it can be negotiated. The clauses can be in that contract can be negotiated or drafted at the very last minute, so that they can close off the transaction. So they may bring issues of interpretation in terms of probably specific performance, where in case of a dispute, someone may quote those timelines as probably having been of contention, but it's a contract that is negotiated when the time that approaches will cause a difference in terms of dates. Thank you.
Okay, thank you. Thank you so much, Bwana Yeko. So to say, for example, if you get a client that needs to purchase a car and you draft for them a contract of sale of that car, it will be a midnight clause. Anyway, it's okay. We will review the question.
Not really. Maybe if you can give me another 20 seconds, I can redeem myself. Huh?
No problem.
What it basically means, and I want to look it from a stock market point of view, because I love the stock market. There are those transactions that are they're always they're always done at the close of the trading period. If the market is closing at 5 p.m., that is the time when you're striking your payments in order to acquire them. So a midnight transaction will be that transaction that is being done at the close or at the time of the deadline of that transaction. Thank you.
All right, thank you. Angelo, we will give the remarks on the review.
Okay. Thank you, Esbon. Like I promise again, I'm going to be quicker. I believe Mr. Bernard actually tried to answer my questions correctly. Like the McNaughton rule, that one he did really well. Okay, it is just aspect of sanity. Okay, it is applied to determine whether the accused person was sane at the time of committing a crime. Although you have drawn your answer to murder, but yes, it is that aspect of sanity, but now it refers to crimes. I was not also happy a little on how you differentiated murder and manslaughter. Not that your answer was wrong, but it was the fact that you mentioned a section of law that was not correct. So please, unless you are sure, because if my memory serves me well, you stated section 201. But I don't believe that is the section that deal with murder, because there are two sections that have to be read together. Okay, so it is not one section that deal with murder. There are two sections. Section X as read together with section Y, because one section provides for the actor's rules, and then the mental element, which you referred to as malice aforethought, is found in that particular section. So please try to not give the section of the law if you are not sure about it. Okay, I don't want to state the sections because I want you to go and find out what are these particular sections. And yes, of course, what is missing between these two, it is the malice aforethought. That is what actually differentiates the two. Because if you look at them, there is loss of life. Okay, that being the case, then the question becomes, was there intention? So the question then becomes the aspect of the mens rea, or what we know as the malice aforethought. That will be the distinguishing factor. On the aspect of the voir dire, others call it voir dire, it depends with where you took your first water. In my village, maybe it was voir dire, maybe in yours it was different. So it is a mini trial within a trial. I believe in some session that we'll have, we will ask you what is trial within a trial, okay? Because there is a trial and there is a trial within a trial. So its purpose is to carry out an investigation of the admissibility of evidence during trial. An example is where it refers to is where the evidence is given by a minor. So if you have watched this series, you realize that, or if you have been to the children's court most of the time, you'll see the magistrate trying to engage the child to see whether he or she understand, okay, the aspect of the case, okay, or what he or she is testifying about. All right, and then to conclude, I believe it is one question that is left, because the ejusdem generis rule, you actually use another principle for you to answer the question correctly, and that is why I smiled before, okay, because it shows that you are a genius, huh? So you can use another Latin such that you can
Thank you.
find what you really want, okay. So that one was really nice. So on the conflict of interest, I don't agree much on the exception that you told me about ethical. If I am a Christian or I'm a Muslim, I'm not supposed to take this case because of my moral belief. I don't agree much with that. Most of the time, I go with the two main one, the conflict of interest, or where you don't have expertise. But there are others whereby, let's say, if there is another advocate that is on record, okay, you have to read Order 9, Rule 9. If there is another advocate that is already on record, so you know you will not have the capacity to come on record, okay, for that particular client, unless two instances, an application is filed, or if there is a consent between those two particular advocates. So that is where you can really come on record. Sometimes time become a factor, okay? So if you don't have time, because you need to give the best defense or proper representation that you can give. Remember the right of access to justice, okay? If you don't have that particular time for you to dedicate to that particular client, you can refuse that particular brief, okay? And then finally, it is that other aspect of if, let's say, the client cannot pay the fee that is required. But you see, these that I'm mentioning, sometimes, they are debatable, okay? Because we have the right of access to justice. That is why I would first go with the main two, conflict of interest, and where the expertise, you don't have that particular expertise at that particular time, okay? I believe, Esbon Oko, that is all on my end.
Thank you so much, Angelo. I'll be very brief because I can see we are at 11:01, 1 minute past our clock. But I'll request for your little patience so that I just take 1.5 minutes to go through the questions I asked. So the first question was, oh gosh, I can't remember the order, but I did ask you about the opening statement. That is very, very important. So the opening statement, you really tried, but I want to encourage you to go look at the deliverables when required to do an opening statement. And first of all, please get conversant with the facts in those two cases, the case of Desmond Peters and the case of Faith Mweni, because you may be asked to give an opening statement in any. So if you don't know the fact, you cannot proceed. So it's very important, guys, go read those two cases. Now, the opening statement, whatever I was testing you on, I wanted to see you bring out these 5 key things. The first one was, did you bring out the theme of the case? Like, for example, what is the theme? For example, you started it well by the way you introduced yourself. Then you start by, this is a case of, for example, this is a case of, for example, a failed relationship or whatever you want, for example, in the case of Faith. In the Desmond Peters case, you, for example, say mistaken identity. You can have your own so that someone knows, oh, so this is a case of mistaken identity, then someone now follows through. But because you're representing prosecution, you need to know the theme you will have to come up with. Then you need to find a theory to run through your story, because you are telling a story. You'll be asked by what is the characteristics of a story. So you ask what is the characteristics of a story, then they're asking about an opening statement, the content of an opening statement. So the theme, the theory, then you have brief facts. You start narrating the brief facts very briefly, and the facts will be the relevant facts that you'll use in your favor, that shall be used in your favor. Then, of course, you can at that point also give out some of the things that will be raised by the other party, so that you preempt whatever the position they hold. That really gives you a strength, because it is your bad fact, because under the fact is supposed to bring out the good fact and the bad fact, so that the bad fact shall be the strong fact for the other position. So once you get a chance to mention them before them, you can actually attack them in a way acceptable at the opening statement. Then you're supposed to show us which evidence are you going to like support your case with. You shall bring, for example, this number of witnesses you're going to give, this type of evidence, and whatnot. Then you need to show us to tell the court what you are seeking. What prayers are you seeking from the court? You'll be seeking this court 1, 2, 3, so that we know from the beginning this is clear. And then also remember, in giving your opening statement, you need to like paint out your case. You need to like build a rapport between yourself and the judges or the panel. So please know those 5 key things when asked about opening statement. They'll just be like keen to know or to hear if you bring out the 5 things. Then the other question I asked you was the question on redemption. I think that one you really answered so well. I don't want to overstate it. You really answered it well. Then but you started it wrong when you mentioned it was in conveyancing. Please be very careful. You may find a very tough and tight lecturer that will not want you to retract once you mention conveyancing. Then the other question I asked you was the meaning of midnight clause. If you read Yellow Pages, that is what you'll get to understand, that it's drafted at night. But whatever you should get to understand as a conveyancer or a commercial transaction, or any person drafting a contract, is that when you talk about midnight clause, they are called midnight clause because they actually prepared at the last time or the last minute of preparing an agreement. Because the substance of an agreement is just like, what are we agreeing? What is the subject of this? What is the offer? What is the acceptance? What is the consideration? And how are we going to work on all these? But now at the end of it, and this is exactly what the mind of any person drafting contracts should have, that when drafting an agreement, you're also thinking of a dispute that is likely to arise, so that you're not just looking at the agreement is going to work very well. No, parties may disagree. So in the case that party disagree, what then shall govern them? And that is now the idea that comes the last minute of drafting an agreement. So that is why now we call them midnight clause. So midnight clause relates to the clauses that speak, so the clauses that speak the dispute resolution. For example, mediation, negotiation, and any before you go to court, this is the procedure. So that is what you call the midnight clause. I don't know if you have any question to us, but that will be all from me and Angelo. Any question to us?
No question. I'm satisfied, Dan and Angelo. Thank you.
All right. Thank you. No, thank you so much. So now, before we now close, maybe we can invite 2 questions. There's a question from Bernard. It could be so burning, it would be very unfair that we go without having a look at it. So I'll just request for your little patience. Then we will close in a few. So Onyango George had a question. He's raised his hand. I'll give him a chance. Please proceed. Onyango, proceed.
Okay. Good evening.
Good.
Thank you for the opportunity. Mine was just a follow-up on the third-party proceedings. My question is on the grounds, because I never got them right. The grounds and when the insurance company can be involved in a suit as a third party.
All right. I'll briefly talk about it, but I'll invite you to go look at Order 1 Rule 15 from 15 to 21. So now, how do you think insurance company will be involved in a third party proceedings or will be given a third party notice? Is, for example, we have, let's say, Car A and Car B. So Car A and Car B happen to get involved themselves in an accident. And Car A happen to have been insured by a certain company. So you understand, like, whatever you insure against some risks. For example, the risks of accident, and really not, you understand the kinds of risk you can insure against yourself or the car. So in the case that that car is get involved in an accident, and maybe you had a comprehensive scheme, you know how it works. So you have a scheme that gives, or rather covers, let's say, a third party. So a third party could be that person who you get involved in an accident with. So by your scheme, the third party can be compensated by your can be compensated. So what it means is you will be sued by this person. For example, you knocked down, you'll be sued. You will be the plaintiff, you'll be the defendant. But you know, like your car is insured, you insured yourself. And so, you know, like in any case which has occurred, for example, in an accident, you can get indemnification from the insurance company. So then what happens is, if you are sued, you prepare a third party notice. It's a prescribed form. If you look at the appendix, the prescribed appendix form in the civil procedure rule. So you fill it and then you serve to the insurance company. So once you serve to the insurance company, you're serving to the insurance company because the insurance company should come as a way of indemnifying the other person. So that is why it is one of the grounds. They're supposed to indemnify the other party. Another case is where maybe they contributed, they ought to have, for example, advised you to do this one or two to your cars, but they failed due to some negligence. Or maybe they just ought to have undertaken some due diligence to you as one of their clients. So because of that negligent act by the insurance company, then they will have contributed to that which you caused. So that is why they'll be joined to the suit as third party on the grounds of contribution. So that is the second ground under which you can join a third party to the proceedings. So once you serve them a third party notice, if you do a progressive reading of that provision of given to you, realize that that third party will have an option of either, of course, responding to support your case or just to give their side. It's important to support your case because they are like they're kind of defendants. The liability that the court shall give, the third party shall be liable to the extent of their liability as provided for in the third party notice. So it's important for them to come on record so that they can actually vindicate themselves or exonerate themselves through provision or further buttressing your defense. In the case they fail to come, that is when you go to section 17, 18, proceeding to 21, that you can actually just let the proceedings continue, a judgment be issued, and then once you finish, you give them, they'll be liable to the extent of the liability in the third party notice, the liability that has been granted in that judgment. That is clear. Okay, I believe that is clear. So we really have taken long on that. You'll allow us to close the session, but before then, maybe I'll invite Daniel now take charge and conclude.
Thank you very much for that.
You're welcome. You're welcome. Daniel, kindly.
All right, that's okay. Angela, you have something to add before we close? All right, I believe Angelo is somewhere. All right, Pielo, maybe if you have something to add before we close the meeting.
Well, It was a pleasure, joining in this particular session. Like I said, it felt nostalgic. It's been like almost 2 years since I did this. And I'm glad at least I've given you a hint of what exactly you should expect. And I suppose you guys have a group, so I'm not part of that group. I think maybe husband would assist if ever you want my number. And yeah, so perhaps looking forward to interacting with you guys, not just on the confines of our laptops, but maybe on the corridors of the bar as well. So I wish you all for your orals. I suppose coming on 24th of this month. Yeah, just S it. There's no in between. And even if it doesn't work out for you, don't worry. You still have the bar. So let the oral exams not be about a threshold of how you should perform, but give it your all at least, for the start, and let God sail with the rest. So have a restful evening, everyone. So back to you, Husband. Thanks.
All right. Guys, I want to say thank you so much for joining, especially to the panelists. I think we had a great time today. I think it's been a wonderful session, and thanks to all of you. And secondly, I also want to thank all those who attended, all the students who are here. I want to believe that you learned 1, 2, or 3 things. I want to believe that we keep getting better and better. From our first session to today, we are having our 10th session. I want to believe that, we are growing together, and it's not just a few of us. Guys, I think for me, I'd just say, let's keep going. Let's keep going. Let's keep pushing. Let's keep doing our best. Let's keep putting our best feet forward. And honestly, the work of your hands is going to be blessed. Honestly and truthfully, I want to believe that something is going to change. You might not get 20 out of 20, but I believe that each and every time we have these sessions and you volunteer yourself, something is changing, that you're growing, that you're progressing, that we're getting better and better. So let's just have that attitude of pushing and pushing. Now, I know you have your notes. I know you have other things to do. I know you have project work to do. My advice would be put your just do your best with the project works. Just ensure that you guys are working together. Ensure that you guys are consulting each other. Ensure that you are doing your best. Your project marks really matter, and your oral marks also matter so much. So please just ensure that you're doing your best with what you have. You're doing your best with what you have. Do not relax. Do not try just to say that, oh, okay, whatever we have, we're just gonna send it like that. Try to go through that work and ensure that you guys are forwarding a good work to the lecturers, because these marks do actually matter. I think that's all from me. And so I'd just like us to pray. Our Father art in heaven, we thank you so much for this session. We thank you so much for guiding us, for leading us, for being with us until now. King of Kings, as we go to rest, may you be with us, may you guide us, may you continue to lead us, may you continue to walk with us, King of Kings, Jehovah. We continue to surrender these sessions to you. I surrender this class to you. May you be with them, may you guide them, may you sharpen their minds. It is in your mighty and holy name that we pray and believe. Amen, guys. Good night.
Amen.
Meet you again next Saturday. Bye.
Daniel, you forgot
Amen.
to give us the lucky winner.
Time is well spent. We are all lucky winners today.
Thank you.
All right.